Good afternoon, everyone. Along with you, I'd like to congratulate our distinguished keynote speaker for that wonderful address, and I would perhaps like to add that given Justice Scalia's comments in Veith that perhaps standing doctrine is like his view of political gerrymandering, that after all this time, the fact that we cannot come up with a consistent rule might argue in favor of abandoning the practice in its entirety. Well, that's all I get to say. I'm your moderator for this afternoon's panel on standing. And I'd like to introduce our wonderful participants here, beginning on my right with Professor Jessie Hill. She is an associate professor of law here at Case Western Reserve University, where she also serves as our associate director for the Center for Social Justice. Her areas of expertise include constitutional law and civil procedure. While she is a relative newcomer to academia and to Case Western, Professor Hill has already distinguished herself as one of the rising stars in constitutional law and civil procedure. To her left is Professor Michael Solimine, the Donald P. Klekamp Professor of Law at the University of Cincinnati College of Law. He is an expert in civil procedure and election law and is the new author of numerous works, both books and law review articles and journals on the subjects of civil procedure in particular. And for almost a decade, I wanted to emphasize here, but he hasn't done it in a while, he has served in his capacity either as counsel or advisor to the Ohio Supreme Court, dealing with issues of procedure and access to the courts here in the state of Ohio. To his left is Professor Jonathan Adler, professor of law here at Case Western. Professor Solimine, we apologize for kind of surrounding you with Case Western people. He is the director of our Center for Business Law and Regulation, and Professor Adler is an expert in constitutional law, environmental, and regulatory law. A prolific writer, he is also not only a frequent writer of scholarly articles, but also a noted blogger and news commentator. So please join me in welcoming all three of our panelists for our discussion on standing.
Thank you. I guess I get the unenviable task of speaking right after our keynote address. I don't know whether actually it's worse to be speaking right after the keynote address or right after being described as a rising star. But in any case, I'm going to be speaking about standing sort of in one particular sense. I want to talk about the end of facial challenges to abortion regulations and the future of the health exception in the Roberts era. So one specific facial challenges as opposed to as applied challenges in one specific area. In several cases, of course, the Roberts Court has turned away facial challenges. And we might think of some of the voting cases, Crawford v. Marion County Board of Elections, the Washington State Grange against Washington State Republican Party, U.S. v. Williams, the child porn case, but also in two abortion cases, Gonzalez v. Carhart, and then before Gonzalez, Ayotte v. Planned Parenthood, which was after Roberts had joined the court, but before Justice Alito. Of course, this turning away of facial challenges in favor of as applied challenges is not an entirely new trend. At least since U.S. v. Salerno, in which the Supreme Court implied that a law was not unconstitutional on its face unless it was unconstitutional in all of its applications. And arguably for much longer than that, the Supreme Court has sort of expressed a preference for as-applied adjudication over facial challenges. But the Roberts Court seems to express a particularly strong preference. And this seems to line up also with Chief Justice Roberts' expressed desire to issue modest and narrow rulings. In this presentation, like I said, I want to focus specifically on Gonzalez and Ayotte. And I want to argue, while on the surface this preference for as-applied adjudication seems to indicate a preference for narrow rulings and judicial modesty, they are really anything but modest, those opinions in their implications. They call for federal judges to rewrite legislation and make judgments in areas in which they have little expertise. They thus assure continuing federal court involvement in micro-legislating the scope of abortion rights. In addition, I argue that the Supreme Court's holdings in Gonzalez and Ayotte which ostensibly turn on the issue of standing to mount a facial challenge to a statute, actually go well beyond that and even threaten to reshape the underlying substantive constitutional law pertaining to abortion rights. So first I want to just briefly discuss what the Supreme Court did in Ayotte and Gonzalez in those two cases with respect to the facial challenges, and then tie this together with the notion of sort of judicial modesty. And then after that, I'll get into the heart of my argument, which is explaining why the Roberts courts expressed preference for as-applied challenges, at least as those as-applied challenges have been conceptualized in the abortion cases, do not serve the ends of judicial modesty, and instead have far-reaching implications for substantive abortion doctrine, and they also promise to continue to embroil the federal courts intimately in future disputes over the contours of the abortion right. Okay, so what did the court do in Carhart v. Gonzalez? Well, it turned away a facial challenge to the Federal Partial Birth Abortion Ban Act, PBABA, which outlaws a particular second trimester abortion procedure known as DNX. Now, there were two primary grounds of attack on the statute. The first was that the statute was written so vaguely and so broadly as to sweep in other more common earlier abortion procedures, and therefore constituted an undue burden on the abortion right. And the court rejected that claim sort of on its merits. And then there was a second, more important claim for our purposes here, which was that the federal statute was unconstitutional because it didn't have a health exception. In other words, an exception allowing the procedure to be performed when it's necessary to preserve the health of the woman. And this is something that the Supreme Court had always held was necessary, from Roe v. Wade up through the most recent decision invalidating a similar state statute in Stenberg v. Carhart in 2000. The court had always held that abortion regulations had to have a health exception. Well, what Congress did with the federal statute was essentially to write a statute that appeared to directly contravene the Supreme Court's 2000 holding in Stenberg v. Carhart, which said the statute had to have a health exception. Any such statute had to have a health exception. Instead of including a health exception in its statute, Congress inserted a bunch of dubious factual findings, declaring that the health exception was unnecessary and that the court was required to defer to those findings. In the second Carhart case, Gonzalez v. Carhart then, the Roberts Court looked at this statute and said, well, we know we've said in the past that abortion statutes are supposed to have health exceptions. And we still think that they are, in fact. But here there's actually a dispute of medical fact over whether a health exception is in this particular context necessary with respect to this particular procedure. And of course, normally we think we should defer to legislatures on disputed questions of scientific or medical fact, but unfortunately, in this case, there's reason to doubt the quality of Congress's fact-finding, such as the fact that many of those alleged facts are demonstrably false. So we're not going to defer, at least not in any dispositive kind of way. But we are going to suggest, in actually a dispositive kind of way, that those medical facts are best worked out in the context of an as-applied challenge, not a facial challenge. And so we're going to turn away the facial challenge. Now, there are a number of odd things about what the court did in Carhart 2. And for the purposes of this presentation, I'm just going to name a couple of them. First, based on an almost identical record to Carhart 1, the court reached an essentially opposite result, but didn't claim to be overruling the first Carhart opinion. There was one difference between Carhart 1 and Carhart 2, which was that, or I guess a set of relevant differences, which is that in Carhart 2, the Supreme Court was dealing with a challenge to a federal statute that had explicit legislative findings in it. And in Carhart 1, it was a state statute that didn't have any explicit set of findings. They were implicit. But the court really disavowed the notion that this difference played any role, either the federal-state difference or the presence of the false factual findings. Even more oddly, the court nonetheless in Carhart 2 left the door open to a, quote, pre-enforcement as-applied challenge in the future, in which the plaintiffs would have to show that, again quoting, in discrete and well-defined instances, a particular condition has or is likely to occur in which the procedure prohibited by the act must be used, i.e. for health reasons. This is odd because it's functionally identical to what the plaintiffs actually did in that case. The trial evidence mainly centered on making precisely that showing. Justice Ginsburg points this out in her dissent. So it's unclear why this evidence was insufficient for the court to rule if that's all the evidence that they were looking for. Okay, now for all of its oddities, though, Gonzalez was not entirely unexpected, at least if you had read the Supreme Court's 2006 opinion in Ayotte v. Planned Parenthood. And I am one of the 20 people who did read that opinion. And spend time thinking about it anyway. In that case, which was a challenge to New Hampshire's parental notice law, the court held that although the parental notice law concededly needed a health exception, which it lacked, the district court should not necessarily have invalidated the law on its face. The court in Ayotte, what the court did there, though, was not just to turn away the facial challenge, but to send the case back to the district court so that the parties could fight over the appropriate scope of the injunction against the law. Now, in making this move, turning away facial challenges, twice, the court talked the talk of judicial modesty. In Ayotte, it actually described the limited invalidation that it was contemplating as judicial modesty. In Gonzalez, the court expressed concern about its, quote, obligation and institutional role if it were to, quote, resolve questions of constitutionality with respect to every conceivable situation that might arise in the application of complex and comprehensive legislation. And again in Ayotte, the court explained why an as-applied challenge and more limited invalidation is usually a more modest route than facial invalidation, because it prevents the federal court from nullifying more of the work of the democratically elected legislature than is necessary. So long as the court, of course, can do so without extensively rewriting the statute and while respecting legislative intent. And, of course, as I mentioned before, all of this sort of lines up with Chief Justice Roberts' expressed preference, for example, in his confirmation hearings, for narrow, modest rulings that don't decide anything more than necessary and so on. In addition, there have been commentators who have also pointed out, suggested that as-applied invalidation is a less intrusive mechanism than facial invalidation. Because, for example, it prevents courts from interpreting statutes in their various possible applications without having concrete facts in front of them. And because it, again, prevents unnecessary constitutional adjudication if it can allow you to sort of avoid the substantive constitutional question. Well, okay, now I want to move on to then why this is not, in fact, there was, in fact, nothing modest about what the court did in Ayotte and Carhart too. First of all, none of the supposed rationales for preferring, in my view, for preferring as-applied challenges over facial challenges would appear to apply to what the court did in Gonzalez. While it may be true that the court didn't nullify, and it, or an as-applied challenge would not nullify an entire law lacking a health exception. So I guess in that sense it's true. What basically the precedent that this is setting for the future is that we're asking federal courts to make judgments about legislative intent in a way that is relatively unguided. It shifts the inquiry from the substantive constitutional doctrine about the health exception requirement, which is actually had been fairly settled and strict, to the issue of what remedy is appropriate if a statute lacks a health exception, in which there's really enormous judicial discretion. Now parties will have to fight over the appropriate scope of an injunction and what the legislature would have wanted to be done with this statute in a highly politicized area with no real standards for making that judgment. And actually other folks have pointed out the way in which sort of severability inquiries, which is what this really boils down to, are areas of completely unguided judicial discretion. And there's a great article by David Gans, a recent article on this topic, for example. And it actually ties in, I think, with some of the points raised in the preemption context, too, by the earlier panelists. But and note, by the way, that there are no, again, one case dealt with a federal statute, the other one with the state statute, yet there were no obvious federalism concerns motivating what the court did here either. I mean, the court's moves in Ayotte and Gonzalez were very similar, despite the fact that it had a federal statute in one case and a state statute in the other. But also, since the court continued to contemplate the availability of a pre-enforcement as-applied challenge, it doesn't appear that the court's decision will encourage any more fact-finding or ensure that there are any more concrete fact scenarios than what had been before it in Gonzalez. in the future. So, I mean, the court didn't change the rules of third-party standing, for example, by which physicians bring these challenges on behalf of their patients. And so there's no, actual woman before the court who has a medical emergency trying to get a quick ruling. I mean, that maybe the court realized it couldn't go that far. I mean, that's just almost absurd. So the court had to keep the door open for third-party standing, which means really there aren't going to be any concrete facts. The factual scenario is not going to look any different in the future than it looked in Gonzalez v. Carhart. And finally, it's not clear how the court's ruling preference for as-applied challenges in this context will prevent unnecessary constitutional adjudication. I mean, okay, in Ayotte, the necessity of the health exception was assumed. In Gonzalez, the court actually still went so far as to state that the Constitution prohibited imposing significant health risks on the woman. So it still made essentially a substantive constitutional judgment. And of course, these sorts of judgments are going to have to shape the way federal courts decide cases and shape injunctions in the future. And in fact, this preference for more limited remedies and as-applied challenges requires courts to potentially decide even more questions than they already do in this area, constitutional questions, and to tackle issues that they most likely lack the competence to tackle. To see what I mean, imagine what parties will now be fighting about in the future. In a future pre-enforcement as-applied challenge, if a law lacks a health exception and is therefore unconstitutional as applied, the obvious question is, as applied to whom? The court has traditionally, basically since Roe, declined to answer this question. The health exception itself has been rather vaguely defined, and its meaning left largely to the discretion of individual physicians. Now, in the future, courts will have the option of simply reading some general health exception into a law. But undoubtedly, parties will now have an incentive to fight over what that health exception should say. Should it say this law is invalid except as applied to women for whom, in reasonable medical judgment, the law presents a risk to their health? Could it be limited to physical health? Will it have to be limited only to women with certain conditions, like the conditions discussed in the Gonzalez v. Carhart case that, DNX might be necessary for women with, say, preeclampsia or cancer, or preeclampsia plus cancer, or, anencephalic or hydrocephalic fetuses, right? I mean, it's this level of specification is kind of what the court is begging for. So this is going to open up a host of questions previously avoided, and most likely avoided for good reason. And then perhaps most significantly, and this is my last point, this reopens the issue of the meaning and scope of the health exception itself. So, and we can think of this kind of in terms of what Professor Darrell Levinson calls remedial equilibration. In other words, Levinson and others have pointed out that the cash value of a right is a function of the remedial consequences attached to its violation. So here, the court has cheapened the abortion right by taking facial invalidation largely off the table as a remedy. And the consequences of this are real and meaningful, since in some instances, and actually the federal PBA ban cases probably are one of them, the game will no longer be worth the candle. As applied suits will not be brought because the remedy is no longer sufficiently desirable to make it worth the expense of litigating. Now, a person who doesn't share my views might say, well, that's good because facial invalidation has always been this kind of windfall to plaintiffs, and maybe on some level that's true, but it certainly changes the playing field. And more specifically, I think the effect on the actual substantive doctrine here is profound as well. Ever since Roe, and perhaps, again, most clearly in Stenberg v. Carhart 1, the Supreme Court had recognized a simple, almost per se rule that abortion regulations must contain an exception that suspend the regulation where the health or life of the woman would be harmed. This requirement was strictly enforced by the threat of facial invalidation, and the result was that most abortion regulations contained a health exception broadly granting physicians discretion to determine whether a particular procedure was medically necessary and appropriate. And there were really not too many attempts to write narrower health exceptions that excluded certain conditions and so on, probably because courts would, either interpret them broadly to save them or strike them on their face if they were insufficient. So in essence, Roe and his progeny created a sort of secondary right to the actual abortion right, a right to protect one's health in this context, and to make medical treatment decisions without government interference, at least in determinations of medical appropriateness. By opening up the health exception to specification and arguably requiring specification of the meaning and scope of the health exception, the court is not only encouraging intrusive federal court involvement in an area where courts have little competency, but changing the actual nature of the right. Instead of decisions simply being delegated to physicians, courts will likely be asked to legislate the meaning of medical necessity while crafting injunctions, most likely resulting in narrower and possibly inconsistent definitions of it, depending on the particular medical context and the particular circuit. Now, again, that may be wise, it may be foolish. I tend to think the latter, but contrary to the views of some, it is certainly anything but modest. Thank you.
Well, first of all, I want to thank the Case Western and Law Review for inviting me to participate in this symposium, and I'm very flattered to be part of such a distinguished group of speakers, including my friend and law school classmate, Professor Jonathan Enton. So I'm going to talk about standing, and I'm trying to I'll avoid as much as possible repetition and duplication between what Professor Nichol said and what Professor Adler is going to say. So our focal point, we were asked to look at standing principles and standing issues, with the focal point being the Roberts Court, of course. So I'm going to talk a little bit about the requirements of standing, a little bit about Hine, one of the Roberts Court's standing cases, and a little bit about the issues of what Congress, what, if anything, Congress can say statutorily about standing. So I understand that Professor Adler is going to talk about the two other cases that Professor Nichol mentioned, the Sprint case and Massachusetts versus EPA. So I'll try to avoid that and concentrate on what I said. But I want to begin and end briefly with something that Congress passed recently with regard to standing, and that's what might be called, although it has the law passed last year and signed into law by President Bush has the boring title, I guess you might say, of it's I believe the official title is the Act of December 19th, 2008, and it's a public law and everything, but it might be labeled the Hillary Clinton Act, and this law was passed. It basically, to simplify somewhat a law that is not a model of clarity, in my mind anyway, it basically retroactively reduces the salary and emollients of the Secretary of State. And the reason being, as I understand it, is that Senator Clinton voted a couple years ago in just some routine, appropriation bill, I believe, to raise the salary or the benefits or something of the Secretary of State. So what, right? Well, there's a provision, an obscure provision in Article 1 of the Constitution that appears to say that someone in the Congress who votes to create an office or raise its salary cannot subsequently serve in that office. I think I'm oversimplifying a little bit what that clause says, but that's basically what it says. And so for Senator Clinton to resign her office and then be appointed and confirmed as Secretary of State arguably violates that provision. And I'll leave it to experts on constitutional law like Jonathan and others in this room to tell us whether that's a frivolous argument or a serious argument. So Congress passed this law, but more pertinent for standing purposes, there's a provision in this law that creates a private right of action for someone to challenge it, and it says Any person aggrieved by an action of the Secretary of State may bring a civil action in a U.S. district court. That actually sets up a 3-judge district court, no less, in the District of Columbia to hear such a challenge. So, why would Congress do such a thing? And more pertinent to our discussion, is it legal? I guess. Why would they use that language? Why do they even need to set that up? So I want to return to that briefly at the end to serve as a framing for my remarks. So just briefly, and again, I'm going to duplicate just a little bit what Professor Nichol said, and I think I'll unavoidably duplicate a little bit what Professor Adler is going to say, but I'll try to avoid it. So, as was mentioned, the word standing doesn't appear anywhere in the Constitution. The words case or controversy do appear in Article 3 of the Constitution. The word standing does not. But for a number of decades now, since the 1960s and 70s, the Supreme Court has said that, there is a standing requirement, and it's a constitutional one derived from the case or controversy language, and among other things, it requires, as was mentioned, that the plaintiff, to get into federal court, has to have an injury that's traceable to conduct of the defendant and can be redressed by a remedy in federal courts. The Supreme Court so those are constitutional requirements that have to be met even before getting to the merits and proving the merits of any case in federal court. There's also what the Supreme Court has described as a set of so-called prudential standing requirements that the court has imposed upon itself, if you will, as a matter of prudence. And so one of these, at least it's usually described as a prudential standing requirement as opposed to a constitutional one, is generalized grievance. That if your grievance is generalizable to a lot of people and is not distinguishable from a lot of other people, a mere generalized grievance is not enough to satisfy standing. So a very quick example of this comes to mind, and that's as some of you may know, that speaking of Chief Justice Roberts, he messed up, did he not? The inauguration. Thank you. I was trying to think of the right words. Or perhaps, President Obama had played a part in that. He graciously said that he screwed it up too. So, and they did a do-over, right? Like, the following evening. So I saw this on the SCOTUS blog. The point was raised, I think only half jokingly, that, could somebody sue to invalidate the presidency before the do-over? I mean, the presidency of President Obama on the basis that he's not the president. And so the blogger said that, probably not. There would be a number of barriers to such a lawsuit. I'm not, not the least of which you might say the underlying merits are totally frivolous. But I'll leave that to Professor Enton as well to whether that's true. But just on the standing issue, it seems to be a generalized grievance that anyone who would file such a suit, it's at best a generalized grievance. So that would be a quick example of that. The court has been unclear about what exactly a generalized grievance is. It's never given a precise definition of it, and just because it's shared by a lot of people doesn't automatically mean you don't have an injury. So that's an area that I think is going to have to more judicial attention has to be devoted to it. But at least a subset, or arguably a subset of generalized grievance, are taxpayers. If you're a federal taxpayer, millions of people pay federal taxes, right? So that seems to be an example of a generalized grievance. So let me talk about that for a couple minutes. There's a line of cases familiar to people in federal courts that basically say, with the exception of Flass versus Cohen that was mentioned, that being a federal taxpayer in and of itself is a generalized grievance and doesn't supply enough of an injury. So the famous case here is Frothingham versus Mellon from the 1920s, which said that if it's if your injury challenging a federal spending law at the time was that my taxes are going to pay it and that's my injury, the law is unconstitutional and I shouldn't have to. That's my injury. These taxes are being extracted from me to pay for the operation of this unconstitutional law. The court says you didn't have standing because that doesn't differentiate you from literally millions of other people, and hence, in the modern terminology, it's a generalized grievance. Well, Flass, which Professor Nichol mentioned, Flass versus Cohen from the 1968, I guess, during the Warren Court, carved out an exception to that, setting up using the famous and confusing nexus test, which said that, didn't overrule Frothingham, but said that if your status as a federal taxpayer has a nexus with the type of legislative enactment being attacked, number one, and number two, had a nexus to the constitutional infringement that you're arguing that the statute transgresses. That wasn't very clear, I know, but the language in Flass isn't real clear either. Then you have taxpayer standing. They distinguish Frothingham on the basis that in Flass, I should say, it was aid to parochial, I guess, higher education, actually, if I'm remembering correctly, from the law in the past, in the mid-'60s. It was challenged on the basis that it violated the Establishment Clause to give money to these religious schools, and that wasn't the challenge in Frothingham. There was no Establishment Clause issue there. In Flass, they emphasized that at least one of the purposes of the Establishment Clause of the First Amendment was to limit federal money going to religious schools and other establishments. What's interesting about Flass is that when it was going through Congress in the mid-'60s, there were actually amendments proposed by Senator Sam Ervin, no less, Professor Nichols from North Carolina, that yes, the Watergate fame, to create a cause of action in favor of federal plaintiffs to challenge that very law. I guess I didn't mention earlier that one of the aspects of prudential standing limitations, although the court, in my mind, has never been super clear about this, but one of the common understandings is that these prudential limitations, generalized grievance, taxpayers, that Congress, if it wants to, can statutorily lift those, can statutorily say that even someone with a generalized grievance or even someone who's a mere federal taxpayer can bring the lawsuit. So provisions, to permit that in that law that was challenged in Flass were voted down. They were proposed by Senator Ervin and others, and they were voted down. So despite that, this interesting fact to me, the court in Flass says no. They under the nexus test, they have the federal taxpayers have standing. So that brings us to Hine. That's been mentioned. So make a long story short, the Supreme Court since Flass has, I think it's fair to say, has narrowly interpreted Flass, and that narrow interpretation continued in Hine. Without going into all the facts, another Establishment Clause challenge. The difference was that in Flass, it was congressional enactment, a congressional law, expressly giving money to religious schools. In Hine, it was President Bush's faith-based initiative that he, as I understand it, funded largely by executive order, not by congressional appropriations per se, but rather executive orders that he issued. And so in a fractured opinion, that's the fractured opinion that's already been mentioned, the court basically said, no, these federal taxpayers in Hine simply did not have standing to challenge that. They distinguished, without overruling Flass, even though Justice Scalia in his characteristically combative concurring opinion said that just overrule Flass, nonetheless the three-justice plurality, which included Alito, Roberts, and Kennedy, said that we're not going to overrule Flass. We're going to distinguish it on the basis that the first nexus test to Flass wasn't met because a legislative enactment wasn't being challenged. It was an executive order of the president being challenged, and that was enough to distinguish Flass. Scalia says in his concurring opinion, no, that doesn't distinguish it at all. I mean, Flass ought to apply here, and he said, logically Flass should apply. Scalia says, and I think Flass was wrongly decided for the reasons mentioned, so just overrule Flass. So that's why it's a concurring opinion rather than joining in the plurality. So, okay, so let me move on. than to this idea of congressional power, which has been alluded to. So in a variety of ways, the court and commentators have said that, I already mentioned that, the imperfect understanding is that prudential standing principles can be lifted in various ways, at least by Congress statutorily providing for standing. And so the court has addressed this issue and probably will do so again before the Roberts Court is over. So one of the important cases here is the Lujan case, Lujan versus Defenders of Wildlife. This is the case Professor Nichol that he alluded to, that he wrote about, and John Roberts, this was in 1993, wrote a comment on that. I think it's fair to say Professor Nichol criticized the Lujan case, and John Roberts defended the Lujan case. Without unpacking all the complications of it, just very briefly, I'm just going to talk right now about the congressional aspect of this. And vis-a-vis standing, is that in Lujan it had what's called a citizen supervision. A citizen supervision is kind of a generic term of art, which basically says that Congress statutorily empowers someone to bring the lawsuit, and more particularly kind of statutorily empowers someone to have standing, in so many words, to bring the suit. The Hillary Clinton law I mentioned, that's what would be called a citizen suit provision. So there was a citizen supervision in Lujan. It said any person, this is the statutory language, any person, quote unquote, could bring a lawsuit in federal court to challenge the action by Lujan, right, who was the Secretary of the Interior at the time. So the Supreme Court, per Justice Scalia, says you can't do that, although the court, it was a little unclear why you couldn't do that. It wasn't merely that the court really didn't expressly say, Scalia did not expressly say that, well, Congress can't, undo the standing requirements, although that's kind of sort of implicit in some of the discussion. The court also said things like, and Lujan again said things like that, well, if we permit that, that'll invade the authority of the president under Article 2 to faithfully execute the laws. If Congress can empower any person, quote unquote, to bring a private lawsuit to challenge executive action. That all said, in other passages in Lujan, the court seemed to suggest that at least within some limits, Congress could, in fact, statutorily permit people to have standing where they wouldn't do otherwise. Just briefly, even in the majority opinion by Scalia says that, in passing toward the end of the opinion, without much discussion, says that Congress, citing earlier cases that seem indeed to say this, Congress can statutorily I'm trying to think of the exact language, statutorily raised to the level of a cognizable interest, injuries that were not cognizable at common law, something along those lines. And then in an influential concurring opinion in that case, Justice Kennedy said that Congress can, when it identifies the person who's being injured and articulates lines of causation in the statute, that it can statutorily grant standing, but it's simply, Justice Kennedy said, it simply can't empower anyone. I think that was his word. Congress simply can't empower anyone to bring the suit. This was played out in later cases. Again, Professor Nichol mentioned the FEC versus Aikens case, where subtly different statutory language was used there. The statute, the congressional statute, empowered an aggrieved person, not just simply any person. Remember, Lujan was any person. The statute at the FEC case was an aggrieved person, which is a kind of a common term you see, I believe, in the Administrative Procedure Act and other federal laws. And the majority opinion there said that, yeah, that was, the party bringing the suit, whose standing was otherwise on thin ice, fell within that that language, and hence could bring the suit. So this is all led to a very rich literature about what Congress can do in this regard. Professor Nichol's article, Professor Adler's work, and many others' work. Professor John Roberts' work article has all contributed to this. So time restraints are going to prevent a full elaboration of this. I can just mention a couple points. I guess one is the defenders of a narrow interpretation of Congress's bill power in this area emphasize, among other things, that if you permit Congress to empower people to bring suits, empower people to have standing, who otherwise would not have standing. A number of arguments on those lines, only one of which is that that lessens the responsibility of Congress. Congress shouldn't be doing that because the Congress has oversight hearings, right? That, how does Congress control, so to speak, engage in the balance of power, the separation of powers, with the other branches of government? Well, it's the appropriations power, right? Congress is the only one that can raise money, and Congress can engage in oversight hearings. And if they kind of delegate that oversight task, if you will, those tasks to private parties through private litigation, the argument runs that upsets the constitutional balance. On the other side, people say if Congress can do it if it wants, and if it wants to mobilize private parties to enforce federal law in federal courts, parties who otherwise indeed might not have standing, but for the statute passed by Congress, well, so be it. That's the aspect of the separation of powers, and there shouldn't be any constitutional barrier to it. I mean, you can argue as a matter of policy whether that's a good idea, whether that's a bad idea, but the counter-argument runs that, there shouldn't be any constitutional barrier to that. So in the moment or two I have remaining, let me go back then to the Hillary Clinton bill. So just to remind you of the language there, it said any person aggrieved by an action of the Secretary of State may bring a civil action. I didn't think I read all of it, to contest the constitutionality of the appointment and continuance in office of the Secretary of State, so on and so forth. So if you follow me so far, I think, absent that citizen supervision, I don't think anyone. I guess I shouldn't be careful. I should be careful about speaking in such sweeping terms about this very, unsettled area of uncertain area of law. But I think, if anyone, seriously wanted to challenge the appointment of Secretary of State Clinton, I think you'd have, as a federal court suit, you'd have a very difficult time arguing you have standing. I think it's a generalized grievance. It's very hard to think of hypotheticals where you wouldn't simply be a generalized grievance of some sort. On the other hand, this language seems to empower at least somebody possibly to bring the suit. Any person aggrieved, right? It's the language that, like in the FEC, it's almost exactly like the language in the FEC case. And more than that, it actually goes on to say any person aggrieved. It just doesn't end there. It says by an action of the Secretary of State. So it's, Secretary of State Clinton would have to do so, or her, or someone who's working for her would actually have to do something, I guess, injure in some way that person, and they could bring the suit. So again, without going into all the details, this would overcome it seems to me, the generalized grievance bar to bringing the suit. I'm not saying this will come up, before the Roberts Court, but it's just an indication of a citizen suit provision. Last point, real quick, is that I have no idea. You might ask, why was this inserted? Why did they insert this in the law? I have no idea. So far as I can tell, this was approved by voice vote on the floor of Congress. There were not committee hearings or anything like that. So total speculation why would they would include such a provision. Maybe it was part of an implicit legislative deal that, we'll help out, our friend Senator Clinton, but we're going to, I don't know, like it was part of the, maybe it was by voice vote, as best as I can tell, no dissents on the floor of either the House or Senate, and, no filibuster or anything like that, and maybe it was part of the deal to get, unanimous consent that this provision was put in there. I don't know. I welcome any speculation on that. on that part. So I'll leave it at that and leave it to Professor Adler to talk about the other standing decisions of the Roberts Court. Thank you.
Thank you. It's a pleasure to be here, and let me join those who have already thanked the editors of the Law Review for putting this symposium together, and I also, on behalf of those of us here at Case Western, would like to thank all of those that made the trip, that came to our snowy part of the world to have this discussion. I know that the students and certainly my colleagues appreciate the speakers of making the effort to be here, as well as all of you that have decided to come here in person rather than to watch a webcast. I should also just note that it is kind of a bit of a personal amusement that I'm not often described as being to the left of my colleagues on a panel, and particularly it's not often that I'm described that way by Professor Koo, and so I just thought I would point that out. I do think, just as an initial matter, it is worth underlining a point that Professor Nichol made in his remarks, that if we're going to talk about access to the Roberts Court and we're going to make generalizations at this point in time, not only do we have to have a little bit of humility about the fact that we're only 3 years into the Roberts Court, and especially given the size of the current court's docket, it's hard to make any generalizations. The court these days hears in 3 years not even as many cases as the court used to hear in 2, and if you go back even further, there are probably terms in the not too distant past where the number of cases heard in a single term rivals that the Roberts Court has heard in the past 3. So we don't have as much to go on. But even on top of that, if we're going to talk about something like access to justice, we have to step back and realize that we're talking about lots of different things. And if we're focusing on one piece of that, we may get a picture that's not fully representative. I think, as some of the earlier panels noted, we certainly see a court that appears to have been more sympathetic to certain sorts of business claims, particularly claims related to preemption. And there's some empirical work that's coming out that suggests that that's particularly true when the business community is able to get the Solicitor General on its side, that the rate of business winning in preemption in similar cases goes up dramatically. Certainly, it appears the court is very stingy when looking at statutory provisions and whether or not to identify causes of action, and reluctant, certainly very reluctant, to adopt new causes of action or recognize new causes of action, even if they are similar to causes of action that the court may have recognized in decades past. What's interesting, though, about a lot of these areas, in distinction to what we're talking about here, is that those tend to be statutory areas. And so they're areas that Congress, if it so chooses, can correct course. And in fact, just this week, Congress passes and the President signed into law legislation that overturned the court's decision in the Ledbetter case, which dealt with the statute of limitations for certain sort of pay equity claims. And so here the court had said, well, we don't think this sort of case sort of claim should be allowed to last for longer than the statute of limitations. But Congress was free to clarify that no, if not the Congress that passed the initial law, certainly the current Congress feels differently. In the standing area, though, of course, that is much harder for Congress to do. I mean, certainly Congress has the ability on the edges, as we've just heard, at least in certain contexts, to create procedural rights or to ease the way for standing. There is language in some of these cases about Congress's ability to create and define procedural rights. But at some level, when we're talking about standing, we tend, and the cases that the court has handed down, we are talking about some irreducible core of Article III standing that Congress can't touch. And so I think it is then particularly interesting that the pattern we may see in some of these statutory areas of a court, or at least a court majority that is particularly reluctant to swing open the courthouse doors, does not seem, at least thus far, given the limited number of cases we have, that pattern is not something we're seeing in the standing area. In fact, I'm going to suggest that what we've seen thus far is a bunch of standing cases, or cases where the court had to address standing thus far in the Roberts Court, of very little consequence. And then one case, Massachusetts versus EPA, of potentially really significant consequence, in which the outcome is not limiting standing at all, but at least for certain types of cases and for certain types of litigants, making standing far easier. And I think that's interesting because I think it adds a complication to the simple narrative. This is simply a court reducing access to justice. And Professor Nichol in his remarks noted that there are other areas where if we think about access to justice broadly, we see areas where the court is constricting the ability of litigants to get into court, but then other areas for other types of litigants, making it easier. Now, the court has handed down a bunch of cases where it discusses standing and a bunch of cases where it's denied standing, and most of these have been very straightforward. Cases like Lance versus Kaufman, a per curiam opinion, or Plains Commerce Bank where the court found standing. A lot of these cases, very straightforward. There's nothing much there. There really have only been a handful of cases where the court has been forced to confront a standing question that divided the current justices. Even a case like Daimler Chrysler versus Cuno, the case involving tax credits that came out of Ohio's effort to provide preferential tax benefits for producers in the state, that did not produce much dissent on the court. The cases that have split the court, though, we have, I think, really three cases that are worth talking about: Hine, Sprint, and Mass versus EPA. The first two, or the first one, denying standing, Hine, I think has already been discussed a little bit, is a really minor case. I mean, to begin with, the underlying Establishment Clause claim under current precedent was exceedingly weak. Whether as a matter of first principles, one thinks it's a sort of claim that should be able to be brought. The actual facts alleged would not have gotten very far. But what's interesting about Hine as well is that, as written, the majority of the justices think that FLAST, this exception to the general bar against taxpayer standing, doesn't fit. I mean, and the distinction that FLAST appears to have drawn, and that subsequent cases like Valley Forge Christian College have drawn between executive and legislative action, is exceedingly problematic. A majority of justices took that position. The opinion for the court by Justice Alito, while upholding the FLAST distinction, goes out of its way to never say that FLAST was correct as an initial matter. And only one justice, Justice Kennedy, willing to say, oh no, this is actually a good distinction. And resting that distinction on separation of powers grounds that I've argued in another paper, are really difficult to square with the opinion or the approach Kennedy has adopted in other cases. That is to say, if separation of powers should be part of our standing analysis, one area where you would think you would lower the bar is in an area where you think that political checks are not likely to vindicate the interest in question. Certainly, protecting the rights of religious dissenters or minority religious groups would be an area where we would not expect the political branches to be particularly solicitous of their claims, and we would need the court to act in a counter-majoritarian way. And that I think stands in contrast to cases like Massachusetts versus EPA, which, according to the court at least, what it is doing is vindicating congressional intent when Congress, in most instances, is quite capable of vindicating its own interests, certainly far more able than, say, the litigants in Hine. But all that said, Hine may have been stingy in its approach to FLAST. It may have maintained this anomaly in the law that many of us that are trying to find coherence in the law find hard to accept or hard to swallow. It may have failed to uphold maybe some of the underlying ideas and principles that motivated the court when it originally held the FLAST decision, but it essentially left FLAST and the subsequent interpretations of FLAST where it found them. So in the most notable case denying standing, the court really didn't do much to close the courthouse door. Another case that's particularly interesting and on a bunch of levels where the court found standing is this case, the Sprint case, a case involving claims by payphone operators for what are called dial-around calls. Basically, if you go to a payphone, and apparently there still are payphones somewhere, and you go and instead of dialing directly, you dial an 800 number to get to your long-distance carrier to then make a long-distance call. The charge for your call goes directly to your long-distance carrier, and the payphone operator doesn't get reimbursed. And so there's a provision in federal law that allows the payphone operators to get compensation from the long-distance carrier. But since these tend to be very small claims, no payphone operator on its own is going to file. And so what happens is they get entities to aggregate their claims. And so in this case, this company, APCC, was an aggregator for these various claims. And what was interesting about the Sprint case is that APCC at least claimed for purposes of this litigation, and that's important, I'll mention why in a minute, that it retained no interest in the judgment. So whatever it got, it was going to turn over completely to the payphone operators. And so then the question was, well, then what's their interest? Why do they get to bring this claim? How do they have standing? This isn't like a key tam suit where the person bringing suit on behalf of the government gets a bounty or gets some benefit from having brought the suit. According to what APCC claimed was they were going to retain and get nothing. And the way the court phrased the question was whether an assignee of a legal claim for money owed has standing to pursue that claim in federal court even when the assignee has promised to remit the proceeds of the litigation to the assigner. Not usually the sort of thing you would expect to provoke a 5-4 decision and strong language from the justices, but it did. And I think the reason it did is this was probably seen by at least some of the justices as a stand-in for some of their other standing disputes. That is to say, the court had never had to pass on this precise sort of claim before. There are all sorts of historical cases involving people bringing claims on behalf of third parties, but where they typically have some interest, like in the Ketam situation. And the majority's view was, well, that's close enough to these sorts of cases, and we can see all sorts of practical reasons why other ways of aggregating the claims, like maybe a class action, might be more costly, might be less efficient. Really, it would be pointless and to insist on that sort of thing. So there's no reason not to let this sort of suit go through. The dissent written by Chief Justice Roberts quite argued that no, well, because we've never done this before, we should not, even on this tiny little margin, make it that much easier to get into court. And so, but the court rejected that view. It said the claim could go forward. It's interesting, again, for the level of dissent that this and disagreement that this case provoked, and it's also kind of interesting that a student note written something like 40 years ago ends up being a key issue in this case, because apparently it's one of the few academic pieces to have actually ever looked at this question and the history of claims brought on behalf of third parties. What makes this case even less significant, I think, in the practical world, is that back in the lower courts, it turns out that now at least APCC claims that it does retain an interest in the litigation. And it is yet at least to be explained publicly why in the D.C. Circuit, why in the Supreme Court, it insisted on pressing the claim that it had standing when it retained no interest, when now in related cases before the D.C. Circuit it is acknowledging that it does retain an interest. This prompted a curious footnote in a recent D.C. Circuit opinion where it characterized APCC's initial position as chameleonic posturing, and it sparked a quite angry concurrence by Judge Sentel, who had the first time around dissented on the grounds that APCC didn't have standing, and is now saying essentially, what gives? You now claim that you had an interest sufficient to satisfy me, to satisfy the dissenters on the Supreme Court, and yet you've spent all this time arguing this position. And presumably at some point we may find out what precisely was going on. Judge Sentel suggests that perhaps there was a desire to effectively get an advisory opinion for a future case in which the issue might be more important. So that was one of the other standing cases that divided the court. Not particularly significant. It found standing, but really on the margin and in a way that it doesn't appear to even have been particularly important for the parties. And that brings us to Massachusetts versus EPA. I mean, I've said before, and I'll say today, I'll say again, I think that Massachusetts versus EPA is easily one of the 2 or 3 most consequential opinions of the Roberts Court thus far, and I think it's certainly the most consequential standing opinion, not only on standing, though, but in terms of statutory interpretation, review of agency denials of rulemaking petitions, and the practical matter of whether or not the EPA has the authority and is required to regulate greenhouse gases. This is a mammoth case. And in this case, I think in 2 ways the court unnecessarily altered the law of standing and expanded the ability of litigants to get into court. And what I mean by unnecessarily is I think, anyone that's looked at all the standing cases, and as Professor Nichol and others have noted already, there's lots of give in terms of what we characterize as an injury, what we mean when we say injury to the party, not to the environment. There were ample opportunity for the court to simply say, look, this is just like all sorts of other environmental standing cases. Global warming's a really big potential injury, so your particular share of that injury or the particular thing that's going to happen to you can be smaller because since global warming is so big, it doesn't, your share of the effects or the particular effect to you doesn't have to be all that great for it to be cognizable. I mean, I think the court could have easily done something like that and generally left the law of standing where it is. But that's not what it did. What it did is it did two things. One, that got a decent amount of attention in Chief Justice Roberts' dissent, was that it invented, discovered, created this new idea that states are entitled to special solicitude in Article 3, the Article 3 standing analysis. And then the second thing it did, and something that I don't think has been remarked as much upon, but I think is potentially important, is it expanded the range of instances in which expanded the set of cases in which the court is going to find that Congress has created procedural rights that would lessen the requirements of redressability and causation in the standing analysis. The court said that's what it was doing, and it found a procedural right in a statutory provision unlike any where we've ever found a procedural right before. And if we take the court seriously on that point as well, that could have all sorts of consequences in other areas. And let me take a minute, or how much time do I have? Okay. Let me take like 1 minute each on state solicitude and these procedural right provisions, just to kind of explain what the court did. On special solicitude, the court said explicitly that states are not normal litigants for the purposes of invoking federal jurisdiction, that they get an extra thumb on the scales. And the court spent a bunch of time on this, and as Chief Justice Roberts noted in his dissent, if the court was simply applying traditional standing analysis, this discussion was completely unnecessary. And to do this, it relied upon a case from 1908 called Georgia versus Tennessee Copper, a case involving an equitable or a nuisance case where the state of Georgia sought equitable relief against a polluting facility across state lines. The case had nothing to do with Article 3 standing. And kind of ironically, it's a sort of interstate nuisance claim that under the very law at issue in Massachusetts versus EPA, the Clean Air Act, would almost certainly be preempted as a matter of federal law, given the way the court has interpreted other pollution control statutes and their effect on the interstate common law of nuisance. And this case was also not mentioned in any of the briefs before the court. Not a single party before the court that addressed the issue of standing thought that Georgia versus Tennessee Copper had anything to say about states' ability to bring these claims. There was even a brief filed on behalf of several states arguing that states should get a special consideration because they have certain special interests. And that brief argued that because states face the specter of preemption, that should be recognized as an injury. But that's not what the court did. And they didn't mention Georgia versus Tennessee Copper. The only special solicitude that Georgia got in that case was the ability to seek equitable relief, whereas a private litigant would have had to have sought money damages for the sort of nuisance complained of. Where did this case come from? Well, the best we can tell is it came from Justice Kennedy, because in oral argument he asks the attorney for the Commonwealth of Massachusetts, what's your best case for standing? Massachusetts attorney stumbles a little bit, and Kennedy says, well, I think it's Georgia versus Tennessee Copper. And I don't have any proof of this, but I am fairly certain at that point Justice Stevens got out a pen and wrote a note and passed it to one of his clerks and said, find out everything on that case. This is how we're going to get Justice Kennedy. But I think the fact that no party thought to mention this case in what was an extensively briefed case, and a case in which everyone knew standing was going to be a major issue, reinforces how weak a read Georgia versus Tennessee Copper is to rest this idea that states get special solicitude. Now, the other area that Massachusetts versus EPA had an influence was this idea of procedural rights. And the court, relying on language from both Scalia's majority opinion or plurality opinion and Kennedy's concurrence in Lujan, noted that the normal standards for redressability and immediacy are relaxed when a statute vests a litigant with a procedural right. Now, I think it's obvious in the climate change context why the court would want to do this, insofar as we're talking about changes that manifest themselves over years, if not decades, if not centuries. A very tight imposition of a requirement for immediacy and redressability might make it difficult to satisfy Article 3 standing. But to do it to loosen the restrictions in this way is particularly difficult, because the provision the court cited for lessening the requirements was Section 307B of the Clean Air Act, which is not a rights conferring provision. There's a separate provision in the Clean Air Act, actually, that authorizes citizen suits. It's indistinguishable from the provision at issue in Lujan. under the Endangered Species Act. Section 307B is a jurisdictional provision. It's the part of the Clean Air Act that says if you're filing a petition to review an action by the EPA of nationwide scope, you go to the D.C. Circuit. If it's regional in nature, like you're challenging a state implementation plan, you go to your regional circuit. There is no language in 307B of the sort that we have ever recognized as rights conferring, let alone, as the court suggested in its discussion, is it an instance in which Congress, as Congress has identified the injury it seeks to vindicate and relate the injury to the class of persons entitled to bring suit. In Massachusetts versus EPA, that's what the majority said Congress has to do when creating a procedural right, and Congress didn't do that in the Clean Air Act. So if we take the court as its word, what does this do to all the other regulatory statutes out there that have similar jurisdictional provisions? Do they now suddenly confer procedural rights as well? Perhaps. If so, I certainly don't think that's what the court intended to do, but unfortunately, lower courts don't get to say, well, is this what the Supreme Court really meant to do? I mean, the Federal Circuit, every time the Supreme Court screws up a patent case, doesn't get to say, well, we know more about patents. The Supreme Court didn't really mean to do these things. The D.C. Circuit doesn't get to say, well, we know administrative law. We know the Supreme Court didn't really mean to do what they said. I think this is a potentially quite significant increase in Article III standing, what the court did not consider. So whether or not we think standing requirements play a useful role or not, whether or not we think the Roberts Court has reduced access to the courts and access to justice in other areas, my modest claim here is that in the context of Article III standing, if anything, they've done quite the opposite. They have expanded the ability of citizens to seek redress, and it's quite possible that they didn't really realize they were doing it. Thank you.
Just 2 quick points. There's another range of access cases. There's another range of access cases that nobody's talked about yet that's analogous to the ones that Jessie mentioned, and that is whether or not there's pre-enforcement facial challenge reviewability agency regulations as opposed to statutes. And there's a case before the Supreme Court now. I can't exactly remember the caption. It's Earth Justice, and I think even David Vladeck Summers was on the brief in which the court's going to have to face that issue. And the argument on behalf of the Solicitor General framed the circumstances in which the court should recognize facial challenges in very, very, very narrow terms. Right. So we'll see what and framed it in terms of rightness, I think, as opposed to standing terms. And the second point I'd make is that, as Jonathan pointed out, Chief Justice Roberts dissented in Massachusetts versus EPA. In fact, he wrote a furious dissent, maybe even an apoplectic dissent. So I would say that case is a product of the Kennedy Court, not the Roberts Court.
If I could really quickly, it is worth noting, Chief Justice Roberts is not only one of, the only or 2 of the justices that have written articles on standing, but if you look at the big standing cases, I mean, he wrote the majority in Kuno, which I think a lot of people thought was going to be a roadmap or laying down markers for generalized grievances for other cases. He wrote the dissent in APCC. He wrote the dissent in Mass versus EPA. I mean, he has chosen written opinions in a large number of the cases in which standing was an issue, and even in cases where the court found standing, like in Fair versus Rumsfeld, he wrote the unanimous opinion there. And so, I mean, this is clearly an issue that he's taken a big interest there.
I wanted to ask the panelists, but maybe Jonathan in particular, to take Nick up on his challenge, which was to say, does standing ever benefit the left? Do standing restrictions ever benefit the left? Or analogous restrictions like ripeness restriction, mootness. The only cases I can think of offhand are the cases that essentially stripped federal courts of jurisdiction over takings. San Remo Hotel, in conjunction with ripeness requirements of Williamson County, has taken takings cases against states out of federal courts to the fury of property rights advocates. And that was a Rehnquist court situation, of course, but I'm wondering, are there any Rehnquist/Robert courts decisions where essentially the court foreclosed the federal courts to conservatives, aside from San Remo Hotel?
Sure.
So give a few examples.
Well, I mean, there's a takings case with John R. Sand and Gravel Company, which is a statute of limitations case, and which is interesting to pair with, there's a case, I think it's BP Exploration, which is like the flip side about whether or not statute of limitations run against the government when it wants to get paid back for royalties that it was owed and it didn't get. And the government wins in both cases. The taxpayer standing cases affect at least some conservative groups. I mean, there are a lot of conservative groups that are really upset about preferential tax credits, like were at issue in the Daimler Chrysler case. There are conservative groups now that want to challenge portions of the TARP. And now how they're ever going to get standing to do that is beyond me, because that would, that spending clause. And then, you certainly have folks, John Eastman would be a good example of this, who think that, the spending clause should be justiciable, and that, earmarks and all these sorts of things should be challengeable. And the Roberts Scalia view of standing basically says to those folks, take it to Congress. If you don't like a bridge to nowhere, if you don't like, whatever, we as courts have nothing to do with it. Now, those aren't issues that are as frequently litigated, but perhaps that's because that door has been shut for so long.
I've heard quite a bit of buzz lately about the Supreme Court clerkship, the clerks who kind of decide what cases get heard by the Supreme Court. And I wonder, should we look at the number of cases and the types of cases that the courts take as an example of the justices of the Roberts Court's policy on access to justice, or is this some kind of almost administrative matter, this kind of gray area where it's not necessarily policy? We don't know quite how to put it. We'd love it if the policymakers, if the appointed people were the ones making these decisions, but as a practical matter, that's impossible.
I think it's hard. There have been a lot of people that have written accounts saying that there is institutional pressure against recommending cert grants. Up until last year, 8 of the 9 participated in something called the cert pool, which basically means they pool their efforts to review the cases. Justice Stevens does not. Justice Alito recently announced he was withdrawing from the cert pool. I don't know if that's started yet or not, but there certainly has been discussion that if you're writing the memo for 7 justices, you don't want to be the one that seems like a loose cannon saying, oh yeah, take this case, take this case. How big of an effect that has, I don't know if we know. And I think if the number of cert grants goes up after a second justice leaves the cert pool, that might give us, some data that we could evaluate that with if we see a measurable change.
All right, thank you very much, and thank our panelists once again for their wonderful presentation.
Thanks, sir.